Oops. Here's my band.
Commonwealth versus Brown.
Thank you.
Good morning, Mr. Sultan.
Madam Chief Justice, and may it please the Court. Defendant Eric Brown was charged and convicted of first-degree murder for shooting to death two people he didn't know in Boston's South End on June 16, 1996. After his arrest, Brown was committed to Bridgewater State Hospital, where he was diagnosed and treated for more than 4 years for paranoid schizophrenia. During that period, he experienced hallucinations, delusions, all kinds of other psychotic symptoms, and at one point during that period, he was deemed incompetent to stand trial. Shortly before trial was scheduled, in March of 2001, Judge McDaniel held a truncated competency evaluation, found Brown competent, and trial proceeded. At trial, the Commonwealth presented evidence that Brown had a friend.
Excuse me, you said, when was this? Was this March or January?
Well, it was in March of, there was a hearing in January of 2001.
And he found him competent?
He did. And then at the...
and said there should be another hearing in March just to touch base and make sure.
Correct. And at the end, on February 28th of 2001, defense counsel filed an emergency motion for a new competency evaluation, supported by an affidavit in which counsel said that during his conversations with Brown to prepare for trial, Brown was hallucinating, he was unable to understand counsel, and he was unable to assist.
Mr. Sultan, was this when the defendant stopped taking his meds?
It was, Your Honor. It turned out that the defendant had stopped taking his meds several weeks earlier, and that was clearly something which, based on the record, exercised Judge McDaniel and I think contributed substantially to the proceeding that ensued.
So the judge did have another competency hearing in March.
Yes, if I could, Your Honor. What happened was the motion was filed with the affidavit and also supported by an expert evaluation done by Dr. Price saying that Brown was incompetent in early March. Judge McDaniel had Brown evaluated for competency by the court clinician. The court clinician on March 7th found Brown incompetent. Defense counsel, after that 15A, that evaluation under 123, Section 15A, defense counsel asked for a 15B evaluation, sent him to Bridgewater, and have him evaluated. Judge McDaniel denied that motion on March 12th. On March 14th, in a different courthouse, Brown had a Rogers hearing at which the hospital went in saying he was not competent to make treatment decisions and asked a judge to essentially allow substituted judgment so he could be forcibly medicated. And the judge at the Rogers hearing did find that Brown was incompetent to make treatment decisions and ordered him forcibly medicated. Judge McDaniel refused to order a tape of that hearing. He refused to read any of the records from Bridgewater relating to Brown's condition. He refused to send him to Bridgewater for a 15B evaluation. Instead, he appointed at the Commonwealth's request an expert chosen by the Commonwealth to evaluate Brown for competency, Dr. Annunziata, and he held a hearing at which the two doctors from Bridgewater came in and said Brown was decompensating and he was psychotic. The defense expert said that Brown was not competent. Dr. Annunziata said he was competent. And Judge McDaniel, refusing to do the 15B evaluation, refusing to get a tape of the Rogers hearing, refusing to look at the Bridgewater records, basically said, Annunziata says he's competent, let's go, and the trial started. That's what happened immediately prior to trial. And I maintain that what I say is a truncated proceeding, did not comport with the statute, certainly the purpose of the statute, which is if you get a 15A evaluation saying the defendant is not competent, particularly where it's buttressed by an affidavit from the lawyer saying this guy is hallucinating, we can't talk to him, You're supposed to send them to, and an expert evaluation, send them to Bridgewater for a 15B evaluation.
Let
That
me
wasn't
ask you
done.
a question that's not really, this is more hypothetical than specific to this case, but I think this case raises a very interesting question. What is a judge to do when a client stops taking their meds and puts themselves in this condition?
It's a serious issue, Your Honor.
Do you
and there
turn
are-
it over to the client to kind of control whether they're ever going to be competent for trial or not? Wouldn't we have a scenario where every time you got close to a trial date, the client could just stop taking their meds, and then you have to go through all of these steps, and you get them back on the meds, you get them competent again, and then before trial they choose to stop taking it again?
Yes, that hypothetical is possible, and the Supreme Court has addressed in the Sells case whether or not it is constitutional, essentially, to forcibly medicate a defendant, or whether a defendant has the right to present himself to a jury in an unmedicated state. This case does not squarely address that, but I think the hypothetical certainly is raised by this case, but it's obviated by our proceeding for a substituted judgment. If that was going on, then and the defendant needs the meds for medical reasons and cannot properly make the decision does not have the judgment to make that call, the hospital can go to court and get an order and forcibly medicate him. If the defendant does have the ability to basically, if the defendant is sort of deliberately manipulating the system, if that's what Your Honor is suggesting, and the defendant is making a rational decision, I don't want to go to trial, and therefore I'm going to stop taking my meds so I can't be competent. I think that poses a very knotty problem, but I think that a judge could find that the defendant is deliberately manipulating the system.
No, but there's no such evidence here.
No, there isn't, Your Honor. Not at all.
And it seems to me that one of the difficulties, I don't know if it's in this record and maybe we can or cannot take judicial notice of it, but one of the problems of treating schizophrenia is that lots of schizophrenics go off their meds lots of times. I mean, so you would have to have a pretty clear record of timing of when somebody is on and off.
And certainly, based on the records in this case from Bridgewater, Brown had gone off his meds a number of times for all kinds of reasons, because he thought he was being given instructions by voices, or because he thought that people from other galaxies were chasing after him. So there was no evidence in this case that he was sort of playing a game. And certainly the evidence was to the contrary, and in any event, even if Judge McDaniel suspected that, I don't think the appropriate resolution is, I don't care if you're competent or not, I think you're playing games, we're going to trial. That is not within the Court's discretion constitutionally or under the, I think, very complex and very helpful statutory scheme that's set up to evaluate competency, which was effectively ignored in this case. Yes, he held a hearing, Justice Cordy, but the hearing, I say, was a hearing in form and not in substance, and Judge McDaniel essentially decided to be willfully blind to the evidence that the defense wanted to present as to their client's.
But I mean, isn't it another way to look at this is the defendant had been examined and examined and examined again and examined and examined, found competent at one point, incompetent at the next point, competent at one point, there's 4 years of history here, right? So the judge isn't just saying, oh, heck with it, let me just have a truncated hearing. He's got 4 years of history that he understands from the record.
Yes, Your Honor, but with paranoid schizophrenia, the condition changes. It changes especially if medication
okay, so
has
then
been
if the judge has the hearing and decides at this hearing right now he's competent, this is the time to go, because his condition changes all the time.
Well, that's fine, but in doing so, the judge was obligated to consider all of the relevant evidence, which certainly included what happened at that Rogers hearing on March 14th. It certainly included the Bridgewater records that were within the last couple of weeks. The judge can't simply close his eyes to that and say, let's go, we're going to try this case. It's been 4 years, that's long enough. I understand a court's impatience and frustration. It's difficult for lawyers to deal with paranoid schizophrenics. It's a complicated problem.
Mr. Sultan, it presents a very I'm not so sure that we don't get to the medication, because I take it that as a consequence of the Lodge's hearing, at the time of trial, he was on his medication.
Yes, Your Honor, he was, but
I understand.
it
But
takes a while for it to kick in somebody's system. It has a cumulative effect.
yes, and then the question is, I mean, it's a difficult question because, as you say, you come on and off and on and off, and viewed differently, it might be that somebody happens to be taking their medications, they happen to be caught. That's when the trials. Let's assume there'd been a full hearing but there was a Lodge's hearing, let's say, 2 months before or 3 months before, and so now he's being forcibly medicated, right?
Right.
And that's when the Commonwealth happened, the scheduling, I mean, nobody knows this, the scheduling takes place. Can the state do that, knowing that he can come off his medications?
I think the Sells case deals with sort of a balance in that situation. It can't be simply for the purpose of getting him to trial. There has to be a medical reason to do it.
So then we have an investigation. This happened to be a random assignment out of the Superior Court. I mean, because this disease is, for these purposes, a real challenge to the system.
It is, Your Honor.
Do you know where your client is at the moment?
He's in a mental health unit at Old Colony. He is not in Bridgewater. Right, he was in Bridgewater for a very long time. He is not there right now, to the best of my knowledge. Moving along to the issues of trial, if I may, because most of the issues raised on appeal relate also to the treatment of his mental condition through various points of trial. And first, there was evidence, which was not objected to, that following his arrest, that Brown, and following Miranda warnings, that he declined to make a further statement to the police. That was deliberately elicited by the prosecution. It was essentially alluded to during the testimony of the prosecution's psychiatric expert. That is, he was asked if it was significant to him that the defendant understood his Miranda warnings. And as a comment on the defendant's post-arrest silence, I do think it creates a Mahdi issue, which really struck at the jugular of the defense case here, which is whether this man was criminally responsible at the time. And that's one of the 4 issues which I think are all related that happened at trial. That one was not objected to. The second issue was that after a number of statements of the defendant were elicited, both statements to the police and statements to his friends and others, including statements about the purchase of the shotgun, the prosecutor asked the judge to find that those statements were voluntary. And defense counsel said, wait a minute, Judge, you're going to hear psychiatric evidence during our part of the case, which is directly relevant to this issue of voluntariness. The judge would not wait to hear that evidence. He did not hold a voir dire, which I submit he was required to do, since clearly in a case like this where the defense is insanity.
Can you tell us which statements you're talking about here?
Yes, Your Honor. Statements to, for example, Dwight Bobbitt, the friend who purchased the shotgun. Dwight Bobbitt basically testified that Brown asked him to buy a shotgun, went with him to the store.
So statements made in the course of the crime. We're not talking about after the crime admissions or anything. We're just talking part of the crime.
Well, any statements made by a defendant, which are they're admissible only if they're voluntary.
Well, that's not correct, is it? I mean, voluntary in the sense that they weren't forced, but a statement that a person makes in the course of committing a crime, you suggest, has to be examined to determine whether it was voluntary?
Yes.
Yes.
Yes, I think that's the law.
I'm really wondering about that.
If it's an involuntary statement, then
involuntary in the sense
under Tavares, it's not admissible.
Involuntary in what sense, though?
Involuntary.
This is the gun I want. He says, this is the gun I want.
It's not reliable. If the person is crazy,
This is the gun I want.
But just
And the gun is then
It's
purchased
an
for him.
interesting issue. The case that you're thinking about is that case, the lynching case, where the group went out to lynch him, and the court held, I forget the name of it, but the court held that you've got to prove that the statement was made that wasn't a coerced forced statement. And in that circumstance, people were about to lynch the guy, or were saying they were going to lynch him. And so the court found it wasn't a voluntary statement, even though it was made to civilians.
Right.
Justice Cordy raises an interesting issue, and I don't know that we have a case that talks about it when it's just a statement and it's a race jest, I
Well,
suppose.
it is. Justice Cordy, I agree that most of the statements that on which this
Bradshaw, that kind of
are post-crime statements. In this case, there also are post-crime statements. They're statements he made to the police, which the prosecution claimed were essentially statements which were false statements, which were statements that reflected consciousness of guilt on his part. So it's not just statements that were made prior to the crime, although I submit that those statements also, if they're not voluntary, that's not reliable evidence.
Did the judge actually, or did the judge eventually make a ruling that the statements were voluntary?
Yes, Your Honor. He did exactly the prosecution asked. He made the ruling.
We say, our case law says that you have to do a voir dire. Now, but is there any case out there that says if you don't do the voir dire, but you have made the ruling, that we're going to exclude the statement?
I have not seen that. The Hunter case was a case where there was no voir dire and there was a reversal, but I don't think the judge there made the ruling.
He did not make a ruling.
But in the absence of a voir dire, I guess the purpose of the voir dire is to hear evidence on which you can base a ruling. Yeah. So I would submit a ruling without a voir dire or without hearing the psychiatric evidence is not a ruling based on by preponderance of the evidence or beyond a reasonable doubt. Which is what the standard is under Tavares, and it couldn't possibly stand. So the fact that the judge rubber stamped, did what the prosecutor asked, does not somehow excuse him from doing what this court has required in cases where voluntariness is clearly in play. Now, the third...
My memory, Mr. Sultan, just on that point, is that we have departed from the United States Supreme Court because the United States Supreme Court, as I understand it, now looks at voluntariness only through the conduct of government officials.
Yes, Your Honor.
And we have explicitly said, absolutely not. We want to have evidence that is voluntary for whatever reason.
Doesn't
But
matter.
we have not said that when the statements are made in the course of the crime.
I'm not sure why it should make any difference, Your Honor.
Well, because they're part of the. It's as we hate to use the words "res gestae," but it is part of the crime.
Well, it's
not even offered for the truth of it. It's it's part of what would happen.
If it's a verbal act, I can see that as being distinguished. But if somebody is insane,
testifying about what somebody is saying in their insane state.
If someone is insane, then
I want this gun. Okay, he buys the gun for me.
But he doesn't say that. He says, I want
the freshest.
Yeah, and when I say this is the freshest, that means that's the gun I want. So the gun is purchased for him.
I think for this court to say that Tavares does not apply to pre-offense statements would be a major change in what's been the jurisprudence in Massachusetts for a long time.
We'll look at that.
I can't think of any case that suggests what Justice Cordy that distinction.
Well, if somebody commits a crime at gunpoint, when the person himself is under gunpoint, if what's her name? The woman out in California a long time ago.
Duress. Patty Hearst.
Patty Hearst. If she's claiming that she has committed a crime under duress, does the statements that she makes at the time she goes up to the bank tellers and says, turn over the money, they're admissible, aren't they, even though they're under duress? Her defense is that those statements were made under duress. They were not the whole crime was not voluntary.
I agree it's an interesting question, and I don't know the answer to it. All I know is I don't know a case maybe that has specifically addressed this.
Because it may not have been raised, because classically what you're going to have is the formulation that Justice Spina simply said, you have the whole client as duress, or you say, I was, the more classic thing is, I was incompetent while I was taking this, not a duress one, but a mental incompetence. I was schizophrenic at the time. I was off my meds. I was...
In any event, in this case, many of the statements that we're talking about are statements of the police, are post-arrest statements. Mm-hmm. So I don't think that distinction is dispositive here.
When did the judge make the ruling?
Right after the prosecutor said, I want you to find that these, after the statements came in, then the prosecutor said, I want you to find these statements
For very good reason, by the way.
I'm sorry?
For very good reason.
Of course.
Because the prosecutor knows that if there's an attack on these statements for being not voluntary, it's very likely that they will not be admissible.
The prosecutor knew that this had to be addressed, but,
Sure.
but it wasn't addressed properly.
I understand
I'm running out of time. I do advert in my brief to two other issues relating to state of mind, the exclusion of the Bridgewater records, which the judge refused to allow the jury to see, and the failure to give an intoxication instruction over objection where the prosecution expert said that the defendant told me he was drinking excessively that night. In my opinion, he was drinking excessively that night. The prosecutor argued he was drinking excessively that night. No Henson instruction was given. Two other issues, if I may just have a moment.
Yeah, you may, Mr. Sultan, it's okay, because
Okay.
these are serious
I'm sorry.
cases.
Thank you, Your Honor. The two other issues that do not relate to state of mind. One is sufficiency of the evidence, which I've laid out in my brief. The other is an issue which is that the judge, there were 23 students in the Venari,
Right.
and the judge basically got rid of them all. And he did it not as in Evans, where there was some kind of individualized determination. He basically told them, you don't need to be here, you don't want to be here, goodbye. 3 of them asked for excuses. As to the other 20, either there were no excuses individualized at all, or the judge basically got them to give excuses.
Wasn't
This
the
court, I
judge
think, needs to say
basic-
that's not okay.
Wasn't the judge basically saying this is going to be a long trial?
No, it was very specific, right? It was, you're a student, now tell me, do you have to be, what I didn't, and I was going to ask the Commonwealth about it, yes, you're a full-time student, but they are full-time employees.
Yeah.
They are full-time everything.
Absolutely, Your Honor. And frankly, I
and
can
we
think
do
of a better
not-
thing for a student to do than
Well,
sit on a
that's
jury.
a different issue, but what you say to somebody is, can you handle this?
Yes.
How long was the trial?
The trial was, I think, 3 weeks, or 2.5 or 3 weeks total.
Weren't they advised it might be 4 weeks? That was in the voir dire process, so it was.
I think that's correct, Justice
But
Corey.
again, you say to somebody, everybody was told. Everybody was told, correct?
Yes, Your Honor. And I don't look. I know I can't prove prejudice realistically on this, but I just think this court needs to speak and say this kind of systematic exclusion of students is not the way we should pick juries. And finally, if I may just have 30 seconds on 33E. I know this court has not changed a verdict in a murder case under 33 in a very long time. But there's no way you can look at this record without concluding fairly that this man was severely mentally ill. And I know the answer is tell it to the jury. And I understand that. In my experience as a lawyer in 26 years, I cannot remember a jury in Massachusetts in a murder case finding somebody not guilty by reason of insanity. Juries don't like this defense. They won't buy this defense in a murder case. And that's what 33E is for. It's in situations where there's got to be some valve, some relief valve, where this court can do something to make a result more consonant with justice. And to leave this severely mentally ill man, after this proceeding he went through, sitting there with first-degree murder convictions is not just illegal, but I submit it's immoral. And I ask this court respectfully to do something about it.
Is there a serious question here about the progression with which his mental illness, the rate at which it progressed, the rate at which his mental illness progressed?
Well, Your Honor, the evidence at trial was, and this is how paranoid schizophrenia works, as I understand it, there was a lot of evidence as to changes in his behavior in 95 and 96. He was a well-groomed, well-behaved person, and he became disheveled. He was muttering to himself. He was angry. He was acting out in all kinds of strange ways. So that was part of the process. And there was expert testimony from the Bridgewater people and from the defense expert that is the way that a disease like this, that's the course of the disease. Now, the prosecution expert said, you know, he may not even, the people at Bridgewater may all be wrong, and he's probably malingering. And so that's in the case. And certainly, yes, the jury was free to ignore all of this overwhelming evidence of his illness and do what they did. But I asked the court to do something.
While awaiting trial, from the time he was arrested until the time, how much time was there from the time he was arrested until the time he first went to Bridgewater?
He was arrested in June. He went to Bridgewater in October after he tried to kill himself at Nashua Street. And he was in Bridgewater from October of 96 until he went to trial in March of 2001. I thank the court.
Thank you, Mr. Sultan. Ms. Padalona.
Good morning, Your Honor. Donna Padalano on behalf of the Commonwealth. I will address the competency issue first, if I could.
Can we just deal with the jury issue? I'm trying to find where I read it, but I read the colloquy between the judge. The fact of the matter is that serving for 1, 2, 3, or 4 weeks on a jury trial is an enormous burden on many, many, many people.
Yes, Your Honor.
And it seemed to me that the judge had concluded that for students, that gave them an automatic, you don't have to serve. And I find that deeply troubling because it is often students, not ordinary working people, who can make up courses, get notes, have people videotape. What was happening here?
Well, you're absolutely right. And then the second day of the voir dire, he actually called the students up before he dealt with any other
But why?
jurors.
Why is he treating students differently?
I believe, Judge McDaniel did that because of his long experience in
That's
trying
not
to...
an answer. I'm not asking, but
I understand, Your Honor.
separate and say, first I want to get up all the software engineers. I mean, we really need software engineers. I want to get up all those software engineers. I find
If I could have had Judge McDaniel's ear on the day that he was conducting voir dire, I certainly would have suggested
why
that he
didn't the
conducted
Commonwealth
it.
say something, Your Honor?
Neither the Commonwealth nor the defense attorneys said anything at the time when this was happening. And I believe it's because all of the attorneys were well-versed in Judge McDaniel's
I understand, but it's a reviewing court
Conduct.
that has to look to see whether this conduct of impaneling juries was so inconsistent with your right to be tried by a jury of your peers.
Well, importantly, students are not a protected class, and their hardship is different than the hardship of a working person in the
It's not different from a hardship of a parent, of somebody who really does have a 9-to-5 job.
It is slightly different, though, Your Honor. For example, and the Commonwealth notes this in the brief, the students are actually paying tuition. So they're not just foregoing the opportunity to earn
There's
money.
no finding that they were foregoing the opportunity.
I'm sorry?
You can be ill for 4 weeks and you don't forego the opportunity. There are many colleges that go to endless lengths to make sure that students can make up. In other words, if there's a finding in an individual case, I can't do makeup, I can't do it at night, it's not adequate, I have to be in the lab, I don't have any problem with that.
I understand, Your Honor. It certainly wasn't the ideal way to handle.
I don't want to use up all of your time.
Okay.
But
And I would just, reemphasize that the students are not a protected class. And in fact, when in the brief, when my brother says that the defendant is a peer with the students, I don't think that's quite true either. He was 26 at the time
no, well, that's
when
the
the murders
difference.
happened,
A
and
jury
he's
of your
30
peers,
at the
a jury
time.
of your peers doesn't always.
I understand, but in essence, the defendant was arguing that these are people of my age, and I'm not sure that the
Okay.
record really shows that to be true. Going back to the competency exam, this was not a truncated hearing. There was nothing at all about the competency hearing that was truncated. It eventually became a 4-day hearing that Judge McDaniel held in March. What happened, as you well know, that there was a 15A hearing on March 7th, at which point the defendant was found not competent. The Commonwealth requested to have their own expert. Judge McDaniel could have gone to 15B, but instead he chose to continue under the 15A rubric. And I will point out that the 15B language is that he may consider the 15B alternative. It's not that he must or he shall. And so he continued under 15A. Quite frankly, what more could there have been than what was examined here? We had the testimony of the defendant's expert, we had the testimony of the Commonwealth's expert, and we had the testimony of 2 treating physicians at Bridgewater. That particularly is important because that's why the Bridgewater records were not, Judge McDaniel did not need to call those Bridgewater records in because he had extensive testimony about the defendant's treatment at the time and his demeanor at Bridgewater. Also, the Rogers hearing, for a different reason, was not relevant to Judge McDaniel's decision here because the Rogers hearing was a different standard, different evidence.
Again, and I may not have read everything correctly, Ms. Patalano, but I thought there were comments made by the judge about the fact that the accused had stopped his medication.
I don't believe that the comments at all evinced that the attitude that my brother was.
No. I was just going
That
to
he
the
was-
relevancy question, because
Right.
then if it's because he's incompetent, then it seems to me that the evidence at the Rogers hearing is relevant, because if the reason why he is off his medications is because
Is because he is
he's in-
strategic medication on the defendant's part?
No, it's because he's incompetent, and therefore the fact that he's now, I mean, as a judge, I would certainly want to know that he's now taking his medications
Right.
because he's been forced
And
to
that
take
was
it.
part of the evidence that was adduced at the 15A hearing,
Oh, I
that
thought
he
you- I
was
thought you-
back on his medications.
But I thought you said the Rogers hearing was not relevant.
No, the Rogers hearing happened before the 15A, the
Right.
second 15.
So the judge knew he
The
was...
second 15A hearing that we're discussing here in the March timeframe, just before the trial started on March 30th. So any evidence that would have been relevant from the Rogers hearing was brought to light during the 4 days of testimony that Judge McDaniel received.
So you're saying that the judge knew...
It would have been cumulative.
So the judge knew that he was on his medications because he was being forced to take them.
Right. There was, I think all the parties that were involved here were well aware of, the extensive history, the 4 years prior to the trial. And so I would have to say that, it was in no way truncated. And the timing of the medication, it was clear during the hearing, the 4-day hearing, what the timing was when he went off. In this February-March issue, there was issues a year beforehand about going off the medication so that he could be videotaped, so that the jurors could see the defendant when he was in an unmedicated state. And that was done, and that videotape was shown at trial. But that was a separate issue. And when we're discussing the March hearings, beginning with March 7th and going through to the hearings that began on the 13th, it was clear the timing, and it certainly can in no way be characterized as a hearing in form rather than in substance. This was very substantive, and the judge considered all of the testimony, and in fact he did rely on the Commonwealth's expert when he wrote his decision, and it's within his discretion to do so. And so
Well, just so I understand, he had three doctors saying that the defendant was not competent and one saying he was. Is that right?
At the hearing, he had, I have to step back. The Commonwealth's expert said he was competent. The defendant's expert, Dr. Price, said he was not competent, and I believe the two physicians from Bridgewater did not give a opinion as to the defendant's competency because they were there to testify about his medical treatment at Bridgewater. And so I don't believe that they were asked to give an opinion as to whether or not the defendant was competent. So he had, in essence, Judge McDaniel had dueling psychiatrists testifying, the Commonwealth psychiatrist and the defendant's psychiatrist, which often happens. It's the reality of a competency hearing, and Judge McDaniel, in his discretion, opted to credit the Commonwealth's expert. And so I believe that, there was no error in Judge McDaniel's decision to proceed under Section 15A rather than going from 15A to 15B. If I could discuss the combination of issues about post-arrest silence and the voluntariness. First of all the statements are in the record appendix on pages 116 to 117 that are at issue here, and that is from the motion that the prosecutor filed on the and that he referenced on the beginning of the 7th day of testimony. The prosecutor approached Judge McDaniel at sidebar and said, in the interest of caution, I believe you should make a ruling on the voluntariness. Now, I also want to note that voluntariness of the statements also came up in a motion to suppress, and Judge McDaniel issued a written decision on the motion to suppress sometime before the trial, and that's in the Commonwealth's record appendix, where he said, although it was brought up in the motion to suppress, defense counsel did not argue anything about the statements and did not put anything in his written memorandum of law. And so therefore, I'm not making any decisions on the voluntariness. Or he found some of the statements voluntary in the motion, but the whole breadth of the statements that are on the record appendix 116 to 117 were not considered in the motion to suppress. In any case, what happened here essentially is that the horse was let out of the barn, to kind of use a trite expression, but that was exactly what happened. The statements were all essentially in by the 7th day of the trial, and the defense attorney said, please, Your Honor, can you wait till you hear the psychiatric testimony? I believe it was a strategic decision by the defense counsel not to have to go through a voir dire. And in essence, on the 7th day...
Wait a minute. You just have to explain to me.
Sure.
I mean, why is it a strategic defense if you're essentially going to put on your own expert testimony?
Because I believe that he wanted to save that for the defense case. His psychiatrist, Dr. Rosemarin, was on the stand, I want to say 6 or 7 days for extensive testimony, 3 days of cross-examination. The voir dire would have been would have revealed whatever strategy the defendant had at the point when he was going to put
But that doesn't mean to say that the judge can't wait until he's heard that evidence. I mean, in other words...
And then say what to the jury? Then strike all the statements that come in?
Possibly. I mean, the Commonwealth needn't have said, please make a finding now that they are voluntary.
The judge could have waited. He certainly could have. But the voir dire also would have... the testimony, in essence, obviated the need for a voir dire here as well, because all the statements and the context of the statements were already in. Judge McDaniel already had that information, and the only thing that was missing was the information from the psychiatrist that he would get at the psychiatrist, which
But I mean, that's the basis of saying, at least as I understand it, that's the basis of the defendant's claim that they were not voluntary, was the psychiatric evidence.
But there was also context to the statements that were given to the statements when they came in, the defendant's demeanor when he made them, how was he acting.
But they're going to put on expert testimony. I mean, it's, this is not lay stuff, this is expert stuff.
Right, but I believe that, when it was the Commonwealth that was requesting it, and the judge realizing that it would be very difficult to strike every single one of these statements after they came in. It would be, let's say, for instance, the one statement, the freshest.
Was there psychiatric testimony presented at the hearing on the motion to suppress?
No, not that I recall, Your Honor.
Okay.
I believe it was all from the Lincoln police officers.
Okay, so the insanity defense here essentially triggered the obligation to conduct a voir dire, and the judge did not conduct a voir dire.
Well, I'm not sure the insanity defense actually did trigger the need to conduct a voir dire.
Don't we have cases that say that?
That it often will, but not that it's a mandatory requirement. I don't believe so, no, Your Honor. And this is not a case like Hunter, where the defendant actually asked for the voir dire, and the judge did not give the voir dire, and then the judge didn't submit the issue to the jury. Here, Judge McDaniel did make a ruling on what evidence that he had. It was within his discretion to make that ruling, and then he submitted the issue to the jury to decide the voluntariness, and the jury, of course, did not decide it until the end of the trial when they had all of the evidence, the psychiatric evidence, the expert evidence, to consider along with those statements. So it was submitted to the jury to consider.
Yeah. But
I think that's how it's
he's supposed to make a ruling. I mean, we do have cases where the evidence goes in without the ruling that the statements were voluntary. And if the ruling is not made, we've ordered a new trial. But here the ruling was made. Interestingly, the ruling was made before all the evidence was presented, before the psychiatric evidence was presented. And that's why I was asking, had any of this psychiatric evidence been presented to the judge before that point in time?
At trial, no. At the competency hearing, I think that was all the current.
But the competency to stand trial
Right,
is not
that's
going
what
to
I'm
look to
saying,
see
Your Honor. I'm
whether-
sorry, I'm just thinking out loud. I
Sure.
think that was all the current information. Judge McDaniel was, clearly well aware of this case and had been involved with it for some time. There were a number of judges on the pretrial motions, but Judge McDaniel had been with the case at least since January, and then sometime before then had made some rulings.
Did the defendant renew any motion to exclude the statements after the psychiatrist had testified on the grounds of voluntariness?
I don't believe so. He renewed a motion to admit the Bridgewater records, but I don't believe that there was a renewal of the voluntariness on the voluntariness issue. And again, I think the most important aspect of this was that it did go to the jury, and the jury were the ultimate deciders of the voluntariness, and they did have, in fact, the statements and the expert testimony to consider when they considered the voluntariness of those statements.
Was it argued by the defense counsel in closing? Do you know?
I don't believe so, no. If I could also just discuss the post-arrest silence. First of all, I think that's a misnomer. It was an answer to a question post-Miranda. It was in no way exploited by the prosecutor. It was never mentioned in his closing argument. It was the subject of one question to the Commonwealth's expert that was answered with a one-word answer, and the Commonwealth's expert was on the stand extensively. So it was one question in a very long trial, and to say that the prosecutor exploited this is a gross, I would have to say, I think a gross misrepresentation of how the prosecutor performed at trial.
What was the question precisely?
It is on page 41 of my brief at footnote 17, and I would like to read it. I think it's quite important, obviously. I apologize. Question: assuming that there was some conversation regarding those items, the shotgun and ammunition, and this is a question going to the Lincoln police officer. I'm sorry. This is a question going to the Commonwealth's expert. On the early morning of June 26 of 1996, and that he acknowledged, the defendant acknowledged understanding each of those rights, and that he thereafter signed or read and then signed the Miranda waiver form. Did you, sir, find those observations significant, sir, in conducting your evaluation? And the answer was, yes, I did. And when you look at the transcript, there is a series of dozens of questions phrased like this, in which the psychiatrist replies, yes, I did, or no, I didn't.
I have to say, I don't understand this question. That was my problem with it.
I think that's interesting, Your Honor, and also it sort of leads me to explain, he asked similar questions of the defense expert. And you can, often transcripts will come back reading very blandly, and you can sense the relationship between the prosecutor and the defense expert in the questioning, in which question after question, the psychiatrist expert said, I can't answer that question the way it's phrased. And the prosecutor was unable to get almost anything out of the defense expert because, there obviously was some animosity going on there. But, to say that comment is the prosecutor exploiting post-arrest silence is to misrepresent the record.
But I take it he wasn't silent post-arrest, right? He explained what he was doing. He was advised of his Miranda warnings, wasn't he? He
Yes.
explained what he was doing.
Yes. He said, I'm coming home from a party.
Right.
I dropped off 2 people. I was driving home.
He was advised of his Miranda rights again,
Yes.
and the officer then asked whether he wanted to add anything. This was another officer?
Right. It was
you want to add
basically
anything
he
to
was
what you previously
right.
told us?
He
You
was
said no.
arrested in the early morning hours. The news shift comes on at 7 or 8 o'clock in the morning, and the police officer says, I heard what you said, and do you have anything else you want to add to that story? And he said no. And that was the essence of the statement. If I could just say, the Commonwealth will rely on its brief for the other issues, except to say, as to the intoxication instruction, just as recently, I think as last week in Commonwealth versus Thomas, this court wrote about the intoxication instructions and how much is actually needed to trigger the requirement for intoxication instructions. And in that case, the defendant had bloodshot and glassy eyes, his speech was slightly slurred, and he might have been under the influence of some drugs. That was the testimony. And still, there was no requirement for an intoxication instruction. Here, three of his friends saw him an hour and a half before the murders occurred, and none of them testified about him being difficult to understand, weaving, glassy eyes. In fact, his friends were all smoking marijuana, and he wasn't. And so, there just wasn't enough in this instance of debilitating intoxication to trigger that requirement. And if there are no further questions, the Commonwealth asks that you affirm the defendant's conviction.
Thank you, Ms. Padalona.
Thank you.
We'll take a short break.
All right.